This is Michael Popok, Legal AF. We got breaking news and a brand new law for the first time in 190 years. The 11th Circuit has told Mark Meadows, formerly the chief of staff of Donald Trump, and everyone like him, take a seat. You're having your case tried in state court, not federal court, just as we expected in Fulton County, and you're not coming over to federal court to try to use the supremacy clause to block your indictment. That was Chief Judge William Pryor. I had done the analysis off of the oral argument, which I'm going to show you next, because it's almost exactly what turned out to be the case in their ruling. The 11th Circuit, for the first time in 190 years, has interpreted the federal removal statute that applies to federal officers, Section 1442A1, again, used for almost 200 years. They just made the new law. It only applies to current occupants of a federal office, not to former officers like Trump and Meadows and the rest. They said, you look at the text is clear. The text, Congress spoke clearly. They know when to use the terms when they mean it. And they're saying that if you are a federal officer at the time the action accrues, or in this case, the indictment is served on you, then you get a removal. If you're not, if you're a former, you don't. I saw this coming because in oral argument, you'll see my clip next, they kept talking about this case from October in the 11th Circuit called the Pate, P-A-T-E decision, in which somebody had filed fake federal liens as a retaliation for him being in Dutch with the Internal Revenue Service. And this guy, Pate, who claimed to be a Nigerian prince of some sort, started liening the property of former federal officers. That's the key. And the 11th Circuit said there's no federal crime here because these people are no longer federal officers. Same analysis applies here to the text of 1442A1. So one, they've made a brand new rule, and it's the only rule like it of all the appellate courts. So it is the law of the land for right now that this removal statute does not apply to somebody who's not currently in office. They go through the whole analysis, which I went over in the clip I'm about to show you. And then lastly, they say everything that's, even if it wasn't a former officer, even if he was a current federal officer, Mark Meadows would not be able to remove because of the allegations that are in the indictment, and the 8 covert acts of his all put him outside of just being a chief of staff. Instead, he was in electioneering. He was campaigning for Donald Trump in violation of the Hatch Act, which was a point that was raised by one of the 3 judges that heard this issue, Judge Abudu, a Biden appointment. And so you're going to hear my analysis here because this very analysis is the heart of the decision that just came out. And just to top it off, again, new law, first time in 190 years, federal removal does not allow a former federal officer to take their case across the street to federal court and then try to dismiss their indictment at all. They're staying put. This impacts Donald Trump and anybody else that tries to do this kind of removal. And that's the first ruling. And the second ruling is even if it didn't, if it applied to Mark Meadows, he would have violated his scope of his federal authority, color of his office, and therefore would not get the benefit of removal. Listen to my analysis here coming up right now. This is Michael Popok, Legal AF. We've got some hot off the presses news. Mark Meadows in court today. Federal Court, 11th Circuit Court of Appeals up in Atlanta, 3-judge panel to try to convince them that he was a federal officer at the time that he participated in the conspiracies to overturn the election, and that everything he did was covered by his federal office, and therefore his Georgia state criminal prosecution should be removed or moved or transferred over to a federal court in Georgia. And there, as part of a 2-step process, he'll try to apply the supremacy clause as a defense to have his indictment dismissed. That's what's going on. We had oral argument today, 3-judge panel. Chief Judge of the 11th Circuit, Bill Pryor, a G.W. Bush appointee, Robin Rosenbaum, an Obama appointee, and Nancy Abadu, a Biden appointee, all heard oral argument. And they were fixated on a decision that they just rendered, the entire 11th Circuit, in an en banc decision just several months ago, which means the entire, at that point, it was 12 members of the 11th Circuit heard the oral argument, what we refer to as en banc together. That included these 3 judges, Pryor, Rosenbaum, and Abadu. And in a 9-3 decision, which is a win, the en banc panel decided that there are times when former federal officers don't get the benefit of federal protection. In other words, the question here at the Mark Meadows oral argument that seems to be bothering this panel is how they apply the recent precedent of a case I'll call PATE, P like Peter, ATE, because they're worried that perhaps we don't even get to the federal removal statute that allows federal officers to take their cases to federal court if they're being state criminally prosecuted for their federal activities. Maybe we don't even get to that portion of the removal statute to allow the transfer if it doesn't apply to former officers. In other words, Meadows is no longer the chief of staff. He's a former officer. So they're scratching their heads trying to apply a recent 11th Circuit precedent that, yes, didn't involve the White House or supremacy clause, but dealt with whether a federal officer enjoys certain types of immunities or certain crimes can be charged. And so they got into a whole debate about it. The reason that they're getting all sort of wrapped around their axle on the 11th Circuit is because they have a ruling in October in which a Georgia man who claimed falsely to be the heir to the Kingdom of Morocco tried to get about $3 million in tax return refunds back fraudulently. And when he didn't like the reaction and he was being charged with filing false and frivolous tax returns, he turned around and filed false liens against a number of federal officers to try to pay them back in a retaliatory way. And he filed $33 million worth of liens against an IRS commissioner who had just retired, who just stepped off. So he's no longer a federal IRS commissioner, and also against a former Treasury Secretary of the United States, Jacob Lew. So these two gentlemen were no longer federal officers. And the question in Pate that's bothering the panel now about Meadows is, could Pate be charged with federal crimes related to filing false liens if the people he was putting the liens on were no longer federal officers? So you see why they're worried that and they wanted briefing on this, and they wanted the lawyers prepared today, which they did, to talk about it. First, if they even have to get to the removal statute, 1442B, it's been on the books for a long, long time, to allow a federal officer who's conducting his federal business, his color of his office, who has a plausible federal defense, if he gets his case transferred from state court to federal court. Now, what that means is the indictment, the state court indictment, comes with the case. It goes over, if Meadows prevails, to federal court. The prosecutor goes over to federal court. Everything goes over to federal court, but then they're able to argue directly to a federal judge about the supremacy clause, which we've heard a lot about, arguing that the supremacy clause somehow gives Meadows immunity from suit and his state prosecution should be dismissed under the U.S. Constitution. That's the fight that we're watching, and the struggle we're watching on the 11th Circuit with this three-judge panel as they try to figure out whether the former federal officer even has the right to remove. And then if they answer that question, that he does, and it's not clear that he does. I mean, we now have this 11th Circuit panel that's got this precedent they're trying to apply to this case and map onto the facts. Then the question is, all right, it applies. Then they have to go through whether Judge Jones, who was the lower court judge in the Northern District of Georgia, the trial judge, that already ruled that Mark Meadows has no right to bring his case over to federal court. We got to decide, this panel will have to decide whether he was acting within the color of his federal office when he was doing all of these campaign-like activities to interfere with the election results to help his first-term president get a second term. Is that really part of what a chief of staff is supposed to do? Now, Mark Meadows has argued that it's a hybrid job. Part of it is chief of staff related to the presidential powers and things related to being president, and part of it is being a liaison with his campaign to help him get reelected. And so he's saying that everything he did, the phone calls to Georgia, the attempts to go into the election offices in Georgia, the attempts to try to interfere with the vote count or get ballots thrown out or absentee ballots thrown out, all of that to Mark Meadows' world is part of his job description. It's within the ambit of his federal office. And that's his argument. Of course, the lower court judge, Judge Jones, ruled, no, we can figure out the outer boundaries of your job responsibilities. And even at the outer boundaries of your job responsibilities, this falls outside of it. You don't get federal protection, and you don't get the protection of the federal removal statute. And so that's what we're hearing in this oral argument today, is the struggle about the application of federal protection for somebody who took the job, which is the lawyer for Meadows, Terwilliger is his last name. He used to be in the federal government. And you're not supposed to argue things outside the record. And you're not supposed to testify and bring new evidence to a appellate panel. But that's exactly what Terwilliger did. He said, well, I used to be a federal officer. I used to be a deputy attorney general and an acting attorney general. And I wouldn't have done certain things. And it would have had a chilling effect on me if I had known that I would have to answer for them in a state court criminal prosecution rather than a federal court. So this is one of those panels that sometimes you're able to read the tea leaves, about where they're going with their argument. And I can't tell. Judge Pryor, the chief judge of the entire court, is presiding. I'm sure he's going to write the opinion here. He has, and so does Robin Rosenbaum, a lot of experience here related to things related to Donald Trump. They are the panel that twice rebuffed and punished, if you will, Judge Aileen Cannon for having interfered improperly with the criminal investigation of Donald Trump related to Mar-a-Lago. So they have a lot of experience here, more than you would think, in Georgia, with all things Trump and Meadows. And so, look, if I was a betting man, I think that they're going to find that, this is my prediction, Legal AF prediction here, they're going to find that despite the recent ruling related to the fake Moroccan millionaire and the liens there, they're going to find this federal statute applies on its face to even somebody who's left office, as long as the activity that he conducted was while he was in office. So they'll kind of square the circle and reconcile that decision from October in the 11th Circuit called Pate that they're struggling with. Then they'll get to the merits, which is, let's look at the express language of the statute and determine whether A, he was acting within the color of his authority as chief of staff, or he had stepped outside of it, exposing himself to criminal exposure and liability. And so if he was within, then they're going to find that he can remove. If they're going to find agree with Judge Jones and his fact finding, which is given tremendous discretion, he's given tremendous weight in their analysis, then they will find that there were at least 7 or 8 instances where Meadows, even though he was wearing the hat of the chief of staff, he stepped outside of that and ended up being able to be criminally indicted in state court and have to stay in state court. Therefore, the supremacy clause would not apply. They'll have to decide that supremacy clause issue, I think, hand in glove with their rulemaking about whether he has the right to transfer. All right. That was the analysis. Just off the oral argument, you now have got the ruling. And we'll continue to follow all things in the development of as the state and criminal, federal and criminal, state and local courts try to control what is an out-of-control set of MAGA defendants, including Donald Trump, and in this case, Mark Meadows. Mark Meadows now having lost in his gambit. He's got one road left. He's going to have to try to appeal up to the Supremes to see if they'll take it on this novel issue. But in the meantime, his prosecution continues. We'll continue to follow it. Only one place, the MeidasTouch Network, and on this YouTube channel. And then on a podcast we like to call Legal AF. It's every Wednesdays and Saturdays at 8 p.m. Eastern Time and on every podcast platform of your choice. If you like what I'm doing, give me a thumbs up. We keep it real. We keep it current. We keep it updated. Only one place right here, MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.